Hey guys, as the Manson cases has reported, the answers have been filed in the California case, Manson versus Evan Rachel Wood and Ilma Gore. So they have responded to his lawsuit. We talked a little bit earlier about potential strategies for that. And the Manson cases, I think, has posted the documents or will be, but let's run over them and what they say quickly. Let's start with Evan Rachel Woods. Let me pull it up here. All right, so this is her answer to the plaintiff's unverified complaint. So when somebody files a lawsuit, typically then you would eventually file a responsive pleading, and that's called an answer. It can be other things. And for example, here, the defendants filed this special motion to strike, and it took, what, a year to get heard and decided. So now it's time to answer the lawsuit. Do you admit these things? Do you deny these things? Do you have certain affirmative defenses you want to say? Whatever. This is the place where you do it. And she's doing it. So let's read it. All right. She is responding to the unverified complaint. Unverified just means he didn't swear to the truth of it himself individually, as modified by the court's May 9th ruling granting defendants anti-SLAPP motions as follows. So here you have a general denial pursuant to the California Code of Civil Procedure 431.30. She generally and specifically denies each of the allegations contained in the complaint and the whole thereof, and denies that he has sustained any injury or loss by reason of any act or omission of Wood, and denies that Manson's been damaged in any amount whatsoever, and he's not entitled to relief. This is an interesting thing because that's not how we normally plead answers, say, here in North Carolina, or for that matter in federal court that I've been in, or anywhere. Maybe that's just how they do it there. I don't know. We'll have to see. I certainly haven't practiced in every state. But the point is, normally when there's a lawsuit, you have these numbered paragraphs and you will go through them and you'll say, I deny, admit this. For example, if the paragraph says, so-and-so is a citizen and resident of Los Angeles, California. Well, you might admit that because that's true, right? And you're going to deny different things, or you may not have sufficient information to say one way or the other. So usually we're pretty specific in terms of you have to say for each paragraph whether you admit or deny or whatever. But here they're just doing it generally, and Gore does the same thing. So I assume that's just maybe how they do it out there. And that's fine. They know what they're doing. Then they set out affirmative defenses, and often you need to do this. Some defenses are just generally there. Some are affirmative defenses, and there's a potential if you don't make them early, you could waive them. I'm not going to look up whether these are all required to be alleged at this point or not, because the point is they did allege them, and so we'll go over them. So without admitting any allegations or assuming any burden of proof, persuasion, or whatever, she says these separate independent defenses. The first is a failure to state a claim. For each cause of action alleged therein, fails to state a claim sufficient to constitute a cause of action against Wood. And that's here called a 12B6. It's just, you're going to see that in almost every answer to say that there's some fatal defect. It's often put in there, even if there is no fatal defect. It's just kind of a pleading standard. It shouldn't be, but I don't know that I've seen an answer that didn't have that in there. So take that for what it's worth. It could be a real defect and probably not. All right. Second affirmative defense, no civil conspiracy. And this one I think is important for Wood, certainly. So she's saying that the Manson's causes of action against her are barred in whole or part because he's not alleged and cannot establish facts establishing a conspiracy to commit a specified tort. And that's important because, he certainly has alleged that they, both wanted to get him and they were working together and stuff. But the judge already brought the argument that there was not alleged to a sufficient degree or shown by evidence that there was a civil conspiracy as to the defamation count. So I don't blame Wood at all for hopping on that and saying, hey, and I didn't have anything to do with the swatting either, right? And I didn't have anything to do with the hacking and stuff. Like, I didn't condone that any more than I condoned this groupie thing. So if the judge will buy one, you can't blame her for trying to get the judge to buy the rest of it. And really, it's possible if Wood is successful in these things eventually, she'll just be out of the lawsuit, wouldn't have to go to the trial. Third, affirmative defense, no vicarious liability. And civil conspiracy is a form of that. Vicarious liability is liability for something someone else does. And that's what you allege the conspiracy for. And it doesn't have to be a conspiracy. There can be other reasons why you're liable for somebody. Maybe they're an agent or whatever. So she says the acts against her, or the causes of action against her are barred in whole or in part because he hasn't alleged or can't establish that she can be held liable for any other person's conduct. And really most of the things that Manson says we're done in the lawsuit. We're done, he says, by Gore. So you get why Wood would do this. Fourth affirmative defense, lack of damages causation. She says he hasn't suffered actual harm or injury in fact or lost money or property. Obviously, if you're on Manson's side, you're going to say, no, that's not true. But she's pleading it as a defense intervening cause, that there is conduct and or an intervening third-party conduct that was a superseding cause of the alleged injuries to plaintiff. If you're interested in a discussion of that, you can look at the video that I did on the Michigan case where the parents are being held potentially criminally liable for the conduct of their son, and the discussion of what superseding and intervening causes mean in the concept of negligence and even criminal negligence, which isn't the issue here, but the point is the same. The concepts are there. And basically what that's saying is you got person A here and person C here, and person B comes in the middle and does something that breaks this chain of legal responsibility. And that's really the idea. All right. I got this on the bottom screen. Sorry, I'm looking down. Lack of intent. She didn't have the requisite intent. Okay. Interesting. Statute of limitations, that his causes of action are barred in whole or part by applicable statute of limitations. An interesting defense to bring up when your whole thing in front of a legislature is that the statute of limitations are robbing people of justice. So hypothetically, if Manson were the victim of false allegations, and I know Woodside says that's not true, wouldn't you want him to be able to see justice too without these crazy statute of limitations? So I'm not really persuaded, or don't know any reason why a statute of limitations would have run on the claims that he has made as he's made them. Potentially, maybe, if he wanted to expand his defamation stuff, because that has a short statute of limitations. But generally, to me, his lawsuit seemed fairly timely. But even though it may be inconsistent with the philosophy of what she has said, her lawyers are going to put up every defense they can, and that's what they should do, and they're supposed to do, and that's what they're doing. That's what Manson's attorneys are going to do too. So it can be irritating if you're on Manson's side, but this is how the game gets played. Eighth affirmative defense, First Amendment. Okay, her conduct is protected under the First Amendment. Litigation privilege. We've already seen that come in to some degree, but she's not letting that go. Don't blame her. Common interest privilege. Okay, so I guess her and Gore are working together or something, some kind of privilege, depending on what they said to each other. Standing. He likes standing to bring his claims. So there you'd have to say, well, some of the damage that he's alleging occurred to some other entity and not him, and he's not the right person to be suing for it. I'm not exactly sure what they're going for there. I mean, maybe they could say, well, the damage he's alleging really is a loss of record sales, and that hurts the record company, not him directly. They should have been, I'm not sure about that, but that's what standing is do you have the right to bring the lawsuit? Are you the right person to be bringing the lawsuit is the concept there. Unclean hands and equitable defense. Because of the things he did, he can't proceed. So he did some terrible thing that's going to keep him from proceeding on his claims, that the court, as a matter of equity, should step in and say, no, I'm not going to let you move forward with this. Is that likely to happen? I mean, no, but you got to plead it if you think you can get away with it and get a defense like that. But it doesn't, of course, often succeed. Good faith, privilege, and justification are the 13th affirmative defense. So if the things happened at all, it says they were done in good faith and were privileged or justified. And of course, we know that was an issue to some degree on the defamation counts, but also it looks like just generally things they were saying back and forth to each other, they're trying to say. 14th affirmative defense, attorney's fees not recoverable. He can't state and prove a claim that entitles him to recover attorney's fees. I mean, generally in America, you don't get attorney's fees, but there's so many exceptions to it. I don't know if one applies to what Manson has alleged or not, but they're saying one does not apply. So he can't get attorney's fees, they're saying, no matter what. 15th affirmative defense, no right to punitive damages. Fails to allege facts sufficient to entitle him to recover punitive damages, can't establish a claim for them. I mean, usually you got to have some kind of heightened, nasty behavior to get punitive damages of some sort. I mean, I feel like he's alleged that. I mean, I guess you'd have to go back and look at what's left in the lawsuit. But again, not necessarily a defense that's going to work, but you plead it. No right to injunctive relief. There is an adequate remedy at law. And generally what that means is if there's a problem here, money will be the way to resolve it. And any hardship by some kind of injunctive relief would be greatly disproportionate. Yeah, I know, or I guess he did put a claim for injunctive relief in his lawsuit, but really what's he looking for there? So, mootness, injunctive relief is barred because it's moot. I guess the theory there is they already said what they said, bro. So you can't unring the bell, to quote Sarah Boone. 18th, affirmative defense, permission or consent. This one caught my eye when I did glance through this. This is really the only first time I've really actually reading this. Plaintiff's causes of action are barred in whole or part because the conduct was undertaken, if at all, with Manson's permission, knowledge, acquiescence, ratification, approval, and or consent. He's probably going to disagree with that one. I mean, that's the whole point of his complaint, right? I didn't want you people doing all this stuff to me, but they're saying, well, maybe you did. 19th, affirmative defense waiver. As a result of plaintiff's words or conduct, he's waived it. So he said things that say, okay, well, there is no real problem here. Some kind of form of waiver. 20th, affirmative defense comparative contributory fault. His own conduct and intervening third-party conduct caused all or some of his own injury. So he shot himself in the foot, or someone else shot him in the foot while he was shooting him in the foot. So even if we shot him in the foot, how much do we really hurt his foot? Because everybody was shooting it. That's kind of the idea here. Latches, barred in whole or in part because of that. And that just means kind of like you waited too long, right? Like it's stale. And I don't see that. I mean, he brought his lawsuit pretty quickly, didn't he, after this whole thing got going? So what, again, you could disagree with Manson and saying he was doing it to punish these women for their free speech or whatever. Whatever you can say negative about his lawsuit, I find it hard to believe that he waited too long. 22nd, affirmative defense estoppel. Okay, so again, that's just an equitable thing of, hey, court, you can't let him proceed here. It'd be totally unfair. 23rd, affirmative defense, failure to mitigate. Okay, because of his own conduct, words, actions, or failure to act, his claims for relief are barred or limited because he failed to exercise reasonable care and diligence to mitigate his alleged damages. So, yeah, and generally in the law, you know, if you can mitigate your damage, you're supposed to do that. So I don't know how it applies here, but it is certainly a known concept in cases I've been in. And you allege it if you think somebody could have lessened the amount of damages they suffered or whatever. 24th, affirmative defense, reservation of other defenses. How about that? She has insufficient information upon which to form a belief as to whether she may have even additional unstated affirmative defenses and reserves the right to assert them as this action proceeds up to and including the time of trial. So 23 stated affirmative defenses and 24 saying, I may think of some more stuff. And then prayer for relief, which comes at the end of these sorts of things, that he gets nothing and no relief. And it's all dismissed with prejudice. Judgment entered in favor of Wood. And she's awarded her attorney's fees and costs and anything else the court can think of. So that's the end of her thing here. And let me get that out of here because I want to switch to this other tab, which is Gore's answer. But before I get into it, I'm going to make a comment here, which is the general rule, as I saw it in California, is if you have a countersuit, and they call it a cross complaint. But so if Wood were going to countersue Manson, you're supposed to do that at the time you file your answer. And we didn't see that, right? We just saw the answer. We haven't seen his countersuit. So I wouldn't call that yet because this just got posted. I mean, what if it posted tonight or tomorrow morning or something and it just was in a different pile at the clerk's office or electronically held up? I mean, who knows, right? So I wouldn't say that she didn't do it yet. And also, if she doesn't do it, there's some exceptions where you could do it later. I mean, I'm just telling you the general rule there, which is usually how it is that when you file your answer, and if you have a compulsory countersuit, cross complaint, as they call it in California, you're supposed to file it then. And if you don't file it then, and you depend on some exception later, you're introducing a little bit of risk into the variable. So if this doesn't post shortly, like it actually was filed when the answer was filed, but it just hasn't shown up yet, then I would tend to think that's a deliberate decision on Wood's part to not file a countersuit. It's just my opinion. I could be missing an exception or something. But we did talk about potential strategies. And if she doesn't file a lawsuit against Manson, I mean, one strategy could be, well, hey, look, I'm almost out of this one. If I can get the judge to buy off on the conspiracy angle that there's no legitimate conspiracy alleged, I could be completely out of this lawsuit. But if I file a countersuit, then I'm going to be tied into this lawsuit. And not only am I going to be tied into it, but I'm going to have potentially a very wide range of discovery, right? Because they limited what discovery Manson could get. But as I said before, in my opinion, striking things out of Manson's complaint would limit his discovery of those items and the use of those items to go on the offense, but not necessarily to defend himself if they were making, or if Wood were making claims against him, legal claims seeking money. So I don't know. It could all be wrong because her countersuit could show up tonight, tomorrow, or something like that, or she may depend on some rule that I don't know about. But my guess is if this doesn't show up in the next day or two on the computer for their court's website, that it's a deliberate decision, a strategy to not file this, or for some basis they have. All right, let's move into Gore. Ashley Gore, aka Ilma Gore, her answer. She does the same general denial that Wood does. It's all wrong, bro. Every bit of it. Affirmative defenses. Let's go. Failure to state sufficient acts. And that's kind of the 12b6 thing we talked about. You're just going to see that in answers. No injury or damage. So again, he hasn't suffered anything, that at least not as a proximate result of anything she did. Third affirmative defense, no causation. He's barred from prosecuting the purported causes of action because she's not responsible for any of the harm alleged to have been suffered. Fourth, intervening and superseding cause. We went over that already. The person in the middle is really the one you should go after. Who's that? I don't know, but that's what that concept is. Proximate cause, plaintiff. So whatever injuries he's got were contributed to by himself or his own failures to act, and he either shouldn't get anything or it should be diminished by his own responsibility. Apportionment of fault. She says that his damages, if any, were caused by the negligence and or omissions of other persons or entities, whether or not parties to this action. That's kind of interesting way to not mention Gore, not mention Wood, kind of mentioning Wood, but not mentioning Wood. By reason thereof, his damages, if any, must be reduced by the proportion of fault attributable to such other parties. And to the extent this is necessary, she may be entitled to indemnity from others on a comparative fault basis. Waiver. Again, we already went over that. He did something that waives these causes of action. Estoppel, equitable remedy. Hey, court, he did something really nasty, and so he shouldn't be allowed to proceed. Latches, he waited too long. I don't buy it, but I get why you plead it. Unclean hands. That's kind of similar to the nasty thing there, that you did something really nasty, and so we're not going to let you move forward. Punitive damages barred. And she actually cites some law here. Look at that. 3294, 3295. Didn't expect that. Not going to stop this to look it up because Wood didn't, I think, cite that, but I assume there's some kind of thing there. That there's a limit, like I said before, there's just some kind of special thing you're supposed to plead out to get punitive damages, and they're saying he's not entitled to it. Privilege / justification / excuse. And that is something Wood had put in her thing. Consent. I think this is an interesting one to me, that they're saying that plaintiff and or persons acting on his behalf consented to and acquiesced in the alleged subject conduct. So, I mean, I don't know of any facts that Manson, that suggest that Manson say consented to the alleged swatting that he says happened. I mean, he wanted that to happen. Consented to it, I don't know. But again, I'm saying the lawyers are pleading these defenses, and they may not apply to anything I'm thinking up off the top of my head, but they could apply to some little limited circumstance, or they may be found to apply to none at all. They're in here. They're all the same font and size. It doesn't mean they all carry the same weight. I'm not buying all these defenses. However, they don't need all of them to work. Ratification. That he's barred from prosecuting the cause of action because he ratified them. In other words, he looked at the things that happened and said, yeah, but I kind of agree that this should have happened. I accept that this happened. That's some kind of ratification there. Congratulations. But look at this. We get to the 15th affirmative defense, and it's the statute of limitations, which I don't see it, but we'll have to see. And there is no extra one for saying whatever I think up in the future. And here we have a tidy list of 15 instead of the 24 that we got from Wood. But she still wants the same stuff. Throw this lawsuit out, dismiss it with prejudice. And he gets nothing by reason of this complaint. and she be awarded her cost and granted any such other and further relief as the court may deem just and proper. So those are the answers filed by the defendants, and there's nothing really remarkable in it. The fact they list a whole lot of defenses and it may not all apply as I see them or as you see them, it really doesn't mean anything. The operative situation is they're saying we didn't do this stuff, and if we did it, there's some legal reason why it's okay that we did it. We already knew that would be their stance. It would be anybody's stance. I still think the material thing, but I'm not ready to call it yet, is that there's no countersuit filed at the same time these showed up on the computer. So I don't want to go down that rabbit hole too far because it'd be embarrassed if it showed up like 5 minutes after I posted this video. So let's wait a little bit on that, and then we can speculate as to, whether there's some strategy to potentially file it later or whether it was a deliberate decision to say not going to file it. All right, that's it. Thanks. Bye.